Happy Friday, everyone. It is Friday, April 11th, and it's about 8:30 Eastern Time. We are going to give you some updates on what's been happening in my family law case since last Wednesday. A lot has happened, and I want to share it with you. But first, I want to talk about two things. I actually was shared a profile today. Thank you, Melissa. I was shared a profile today of a father in Michigan, and I want to give him a shout out because I've been following his episodes of podcasts. He's got 3 total podcast episodes so far, and I'm probably going to butcher his last name, but his first name is Dustin with a D, and then Ondovcsik in Genesee County, Michigan, who is battling 7th Circuit of Flint, Michigan. And he has Facebook Live episodes that are called Coffee on the Spectrum. I watched all of his episode 3 today on the way home from Orlando doing my CPR certification. And he has a lot of good points about our constitutional rights and the judicial abuse and the legal abuse that's happening in family court. So I want to give a shout out to Dustin. I've already connected with him on his Facebook. Definitely check him out if you're interested in any of this family court corruption, family court injustice, child trafficking with these governmental agencies, etc. Because he has a lot of great points. So I definitely want to talk to him further in regards to a joint podcast. Another thing that has been happening since I've been getting more vocal the past 3 weeks or so is I've had a lot more people coming to me for help through my nonprofit Justice for the Serlick Children. I have people reaching out to me through my personal page here. I have people reaching out to me on my Justice for the Serlick Children nonprofit Facebook page. And I also have people reaching out to me on my Justice for the Serlick Children at gmail.com email address. So it's clear I need to start writing grants to get funding, as I am actually now considering law school soon. So I can help others with through my nonprofit for low or no cost. So think of like perhaps a sliding scale to help others that are victims of this severe judicial abuse in family court system. So what Pete and I are going to talk about today is my case since Wednesday, April 2nd, so just over a week ago, that general magistrate 11-page recommendations came back in, and then Judge Sandra Upchurch signed it, make it so, literally immediately. There's no way she read through 11 pages, and it's also pretty clear that a lot of that was pre-written out before the hearing where Pete and I testified on March 25th. And that recording is on my Justice for the Serlick Children YouTube page under the playlist for the all of the court hearings that I've been recording or pulling public records on and then posting. A lot of my story is now on my YouTube channel for the Justice for the Serlick Children channel. There are different playlists. So there's a playlist for my weekly updates. There's a playlist for all the judicial hearings between Stasia Warren, the Illinois judges, and then General Magistrate Alex Alvarez. And then there is a playlist specifically for the voicemails my children left me. And then there is also a playlist that literally tells my story, my backstory, so you can understand how we are where we are at with Daytona, Florida, and 7th Circuit in Florida, coming from Illinois Circuit 19 that started in 2020. So we are going to start breaking down the General Magistrate's 11 pages. It is a lot. It is a lot that was definitely fabricated, but this is DIN 154. And again, all of these documents will be scanned and able to be clicked on. So Pete and I are going to kind of go through this. And then as we go through some of them, I'm going to read my responses line by line that I e-filed yesterday, which was a motion to vacate that I filed yesterday. And then I also filed a motion, a notice of appeal to get it to appellate court, to get upper judges court's eyes on it. So we're going to start going through this. So Pete, what one do you want to touch on first? Because we wrote this up together, so we pretty much know what we wrote.
Well, so starting with point number 4. So the magistrate's report reads, the undersigned notes, and the undersigned is the magistrate. So the undersigned notes that the mother's motion for temporary time sharing was filed after several months of her amended supplemental petition for modification of domesticated foreign custody order was filed with the court. When you read how the magistrate wrote that, it's like he's holding it against her that she didn't ask to see the kids sooner. Now, it's interesting because he ends up, before this report even before the hearing, he had denied that motion without hearing any evidence or anything.
Yeah, that was DIN 35.
Yeah.
So that was actually filed July of 2024 by my then attorney, Rick Brown. So it's been sitting stagnant for almost a year now.
So let's think about this for a minute. You originally had your attorney, Mary Jane Nettles, open your Florida family law case in August of 2023. March of 2024, you retain attorney Rick Brown, and then, because by that point you had already been in the courts for more than a year, and nothing had happened, so you tell Rick Brown, your attorney, that you want him to file something with the court to get you time sharing, while everything else is being played out, and you weren't asking for full custody. You were asking time. Just
to talk to them, visit with them, spend time with them, let them know that I love them and I've been down here the whole time.
Couple points on this. Attorney Rick Brown has been a family law attorney for 40 years.
Yeah, 35 plus years.
He didn't seem to have any problem filing a motion for temporary time sharing. Okay. Later on in the report, where the magistrate describes why he dismissed it, the magistrate makes it seem like it was, completely counter to the actual law, that you can't have a temporary, order in place, prior to a final order on it. Now, that's very interesting, because if you actually go back to Heather's Illinois case, they literally filed temporary child custody, not child custody, temporary child support order against Heather.
Yeah.
And it's literally worded temporary, pending a final judgment, then it will become final.
Oh, temporary has been throughout the entirety of this case for 5 years now. It's always been temporary this, temporary that.
Heather got a second attorney trying to get things moving along. That's why they filed a motion for temporary time sharing to try to get some time while everything's playing out. And the magistrate's making it seem like, well, it was months after she started the hearing, so it must not be that important to her. And then later on, he basically says, well, the law says you can't have temporary orders, So it's just, it's mind-numbing.
Yeah. So my response to that was contesting General Magistrate Alexander Alvarez's conclusion that the notion that the timing of the filing of the motion for temporary timeshare should be viewed negatively. This motion was filed for 2 reasons. 1, this was a new attorney, Rick Brown, filing the motion. 2, the children were being illegally withheld from the mother by Justin Serlick and were doing very poorly in Volusia County schools. Mother had lost 3 full years of access to her biological children at this point for no reason other than the father was choosing to withhold any and all contact. There were now active court orders in the state of Florida keeping mother from her children. None. That's what I'm still trying to get to happen, is to have any sort of Florida court orders. Because, the children have been living down here since August of 2021. I've been down here legally when I transferred my driver's license February of 2022. So we're now in 2025. There should absolutely be something in writing in the state of Florida in regards to custody and time sharing and all of that. There's no reason why an Illinois order should still be in effect 3 years later when a lot has changed in those 3 years since they've been down here. So what do we want to talk about now?
I want to go to the number 16 because this is sort of key to understand something about Heather's case. So number 16 basically is from the Illinois DCFS court. It's referred to as juvenile court, and it's ultimately their findings, right? Mm-hmm. So a couple things, for people not familiar with juvenile courts and the DCF court system, it's similar in a lot of states. It is not actually legal court.
Right. It's considered an administrative court.
It's administrative. So the person who sits there as a judge is not actually a judge. Their title is administrative law judge, but they could just,
ALJ is who I mentioned earlier, Dustin out of Michigan. He talks in depth about ALJs today in that episode 3. So yeah.
So basically, what happens in the juvenile proceedings, which or the DCF proceedings, which actually, so there's DCF agency proceedings that happen before the juvenile court system hearings, which happened superseded the family court case. So the DCF agency in Illinois administratively found Heather. They administratively adjudicated her.
Yeah, the words get so jumbled and mixed up throughout the entirety of the paperwork.
Now,
yeah.
So here's the thing: there was originally 2 counts presented to Heather, or 2 charges. The first one was neglect by failure to provide proper housing, education, medical care.
Yep.
And then
there was a housing freeze in Chicago during the pandemic.
Hold on.
Yeah.
The second charge was neglect by creating an injurious environment because the mother, Heather, had mental health issues and there was a history of domestic violence between Heather and Justin.
Which there was.
He was abusing us. That's the charge. Now, the first charge, they completely dropped.
Yep.
They did not actually adjudicate it. They just dismissed it.
Nope.
So
it was dismissed.
The second charge, here's what you need to know. And we actually have the copy of the DCFS investigative report. So we know what the investigator was filling out and what people told them. The notion that Heather has mental health issues came entirely from Justin Serlick. Mm-hmm. When he was contacted by the DCF investigator, his response, and this is what's written in the investigative report,
which we have a copy of. We've read.
Heather lost her mind and she went crazy and she has mental health issues. And then there's more and more detail where he's telling the DCF investigator she has specific mental health.
What he's actually referring to is, I lost my mind in 2020 because I flat out told him that I refused to ever live with him again. So 2020 was the final straw. Him and Mary Serlick telling me to kill myself March 22nd of 2020 in Port Orange, Florida. And I said, I'm done. I no longer want to ever live with you again. We have been divorced since 2013. It's been 7 years now. We're going our separate ways. So that equates to me losing my mind, according to Justin Serlick.
Here's some important context here to follow up with that. At no point in the last 5 years, at no point in any of the reports, no point in any of the notes from the case manager, was Heather ever offered or required to complete a psychological evaluation? No. Like a proper psychological evaluation with a psychologist.
That takes several hours to complete.
These are
never required to do one. No one ever requested me to do one. Nothing was ever done with that. So this mental health issue that is now followed me down to Florida, because of this lovely general magistrate's 11 pages, all stems from Justin Serlick. Last I checked, Justin Serlick doesn't even have an associate degree, let alone a master's or PhD in psychology. So then,
as far as the magistrate goes, so he's in his report, he cites that charge where the actual charge claims Heather has mental health issues. But with the charge is just, it's literally a couple sentences on the paper. There's no evidence that Illinois sent with anything. But again, we have the investigative report. We have so we know
it's a book.
There was never a psychological evaluation ordered or conducted on Heather. Now, in the testimony in several of the hearings here in Florida, Justin has made vague references to, and I'll quote him, Heather, in one of the hearings, he said, Heather has this insanity going on. And
insanity because I want to see and speak to my children. That's insanity, I guess.
So, they allow one party to make a very vague and ambiguous statement, present no evidence or scientific, literally in the magistrate's hearing, and the note is on the magistrate's report. Justin presented no evidence at all.
No evidence, no witnesses.
He questioned me a little bit, and he testified a little bit himself, but that's it.
And that is on the Justice for the Serlick Children YouTube under the hearings playlist. You can watch all of it.
The vague enough notion that Heather has mental health issues, and it's never specified in anything what her mental health issues is, other than in the original Illinois DCFS report, investigative report, where Justin, I believe specifically told the investigator that she was bipolar and suicidal and some other stuff.
But ironically, in 2020, he was diagnosed with type 2 bipolar disorder, and I have a copy of that. So that is the DARBO. That's a psychological term. I do know a lot about psychology, which is why I'm looking at getting my PhD in psychology. DARBO is deny, attack, reverse, victim, offender. And so pretty much everything that Justin Serlick accuses me of doing or having is actually what he's doing or has. So, yeah.
Okay. So I want to move on because I don't want to get hung up on that.
Okay.
I want to go to point 8, or line number 18. So
okay.
18, the juvenile order of ruling and disposition. So again, here's the thing. This is the Illinois juvenile DCF case. They are not a family law case. They can't make permanent custody decisions.
Correct.
They literally, when they close out their cases, the family court schedules what they call a permanency hearing. Okay, so the magistrate is referencing the juvenile order in Illinois, where the I'm sorry, so the original wardship order that gave Illinois Department of Children and Family Services guardianship and discretion over the children. Okay.
Child trafficking.
Then here I want to be clear on a few things, because the magistrate really jumped to some conclusions on it and clearly didn't seem to have the background on some of the circumstances. So he says the original wardship order allowed the father, meaning Justin, but not the mother, to have unsupervised visitation with the minor children. Critically, this order also required the mother, but not the father, to complete the following assessments and cooperate with and successfully complete recommendations for treatment of drug, alcohol, psychological, psychiatric, parenting classes, domestic violence, and individual counseling. Now, a couple things here. One, Justin was initially also required to have supervised visitation. We know for a fact that he was required to have supervised visitation because they were literally scheduling Heather and Justin to see the kids back to back.
So I had to sit there and wait for him to finish. We always got to see them first.
Even when Heather was requesting either to go first so she could leave and not be around, or for them to schedule at different times because, Justin has been her abuser and was her rapist.
Yep.
It's not hard to understand why there might be a conflict when you put those two people in the same spot, forcing them to have an interaction, even if it's just walking across the parking lot.
Yeah. So my response to that, to the general magistrate, in my motion to vacate that was filed yesterday, my response is contesting General Magistrate Alexander Alvarez's statement because there needs to be some clarity on this statement. Justin Serlick was a legal resident of Florida since July 29th of 2020, and since Illinois DCFS does not have jurisdiction in the state of Florida, Justin Serlick was not held to the same standard as Heather Bendl in Illinois. Justin Serlick's one and only requirement was to complete a parenting class for the entirety of the Illinois DCFS case from October 8th, 2020 to December 28th, 2023. Heather Bendl was intentionally waitlisted by Camelot Care's Elizabeth Tevis, and that was reviewed in several videos before this where I actually read the emails to you guys. And Elizabeth Tevis was documented in countless emails between Heather's attorney and Elizabeth Tevis, as well as in attorney Thomas Hunter's response to restore custody with father August 6, 2021. It is documented that Heather Bendl did indeed complete all of the required services that are mentioned in the General Magistrate's statement for number 18. I have parenting class certifications. I had to do a domestic violence survivor class, basically teaching us how to recognize domestic violence abuse and how to break free from it. Ironic, huh? So yeah, that was my response to that line in my motion to vacate. All right, what do we want to cover next?
All right. 22 and, or 20, sorry, really 21 through 23, Heather addressed in the Facebook Live the other day, and that's some sketchy handwritten notes on some of the documents.
Yeah,
and
the altered documents.
You really have to see the video Heather did the other day and look at those documents and,
just decide for yourself what you think was going on there.
These juvenile and family courts that are literally controlling people's lives are, in today's day and age, trying to pass off printed documents with handwritten notes and no minimal details, literally on those two orders that have handwriting on them. You cannot, there's no mention of who the actual judge is.
Right.
So unless you know whose scribble it is, it's not a decipherable signature. It's literally a scribble. It's worse than most doctors on a prescription pad.
Yeah, one could speculate that a judge never even looked at them or touched them.
There's no real date stamp on when these documents were created, and you'll see in the other video.
One is matching dates and one is not matching dates.
One has all of the dates are the same, December 14th, and the other, the three places there's a date on the paper, each date is a different date. So, I mean,
yeah,
you come to your
illegal
own
activity. That's where the illegal activity comes in.
Come to your own conclusions on it.
Yep, for sure.
Okay, so then let's go, because a lot of this is just sort of the some of the actual history.
That was never correct most of the time, because most of the time that he mentions a lot of this, he leaves out my daughter Ariana Serlick, like she doesn't even exist. So it's very clear that General Magistrate Alexander Alvarez does not know my case, does not know my children, and should not be making any sort of decisions in my children and I's life. Yeah.
Okay. The magistrate in line 33 talks about the parties continue. So after Heather and Justin lost the
which are we on 33 now?
33.
Okay.
After they lost their home in Illinois, after Justin stopped paying his half of the rent, and then there was the furnace caught fire. It says the parties continued to live together with 4 children until February 2020, when they were brought to Volusia County, Florida, to stay temporarily with paternal grandparents, Ira and Mary Serlick, after the parents lost their housing. In March of 2020, the parties resumed living together with the minor children in the state of Illinois. They didn't resume living together.
Nope.
The way that's worded is if they went back to being a happy couple. And that certainly did not happen.
No, I have evidence that we were in domestic violence shelters.
In fact, they were, like Heather just said, Heather and the kids were being placed in domestic violence shelters. They were actually prohibited from telling Justin
I had to
were.
sign an agreement that I would not tell our abuser where we were physically located. And that's pretty standard with any domestic violence shelter because they don't want the abuser showing up and causing harm to the victims that they're trying to protect, as well as just causing a scene for all the other victims.
So now
safe place of Lake County, pads of Lake County.
I want to move on to number 34.
Okay.
Because this really, if this doesn't lead the normal common sense person to be able to make some conclusions about what really happened, nothing else will. In late July 2020, the parties permanently separated and the father moved to Florida into his parents' home, leaving the children in Illinois with the mother. Okay, let's think about that. Let's break that down for a second. Justin, who claims Heather is an unfit parent and lost her mind and went crazy,
left us.
Just left the kids with Heather in Illinois and traveled across the country to stay in Florida.
1,800 miles in 2 days on a motorcycle.
Does that make any sense? No.
No, because if he was concerned about the children in my care alone,
you call and make reports while you're there.
He would have never left. Yeah. He would have stayed close, protected the kids, called the authorities. He literally left them, and they didn't even know he left the state until 2 days later when he texted them and said, "I'm back at my parents in Port Orange, Florida," and my kids are looking at me like, "What's going on?"
The reasons why he up and left. Heather does mention that in prior videos, so we don't need to get into that.
Right.
But the likelihood, had he stayed in Illinois, he would have been arrested. Like, we can leave it at that.
Yeah, absolutely. There were police reports filed. My children talked to investigators when Michael G. Nurheim was the state attorney. That he would have more than likely been arrested based on the child abuse charges alone. Let's just ignore the rape charges that were pending. And let's just look at what my son Thomas and my daughter Bianca said in the investigator reports, and it literally says child abuse. Okay. So he would have been arrested if he stuck around, which is why he bolted.
Moving on to number 38.
Okay.
Well, 37 and 38. So 37, the parties now have 3 remaining minor children, ages 17, 13, and 8. Number 38 is the oldest child of the parties. AS was 16 at the time the instant case in Florida commenced, but has since turned 18. The child AS is therefore no longer subject to the jurisdiction of the court, and this report will not address the adult child for that reason. Let's think about this. You have a mother who has extreme concern for the well-being of her children, goes to the extreme measures of stopping everything she's ever known in her life, packing everything up, traveling across the country with no set, true destination place to stay, tows a pop-up RV camper behind her minivan to get it to Florida.
1,800 miles. I had no towing experience. That alone was its own little crazy adventure. That alone.
With no legal knowledge or knowledge of the area, no friends, no connections, takes it upon herself to figure out what she has to do to survive, to get a Florida court case open, because now all the kids are in Florida. Justin was in Florida, and now Heather was in Florida. It took a year. Heather opens the case. So really, Ariana was 14 when all of this started.
Yeah, so when she was dumped down here in June of 2023, she was 16, going on 17.
Yeah, but when everything started in Illinois, she was 14.
Yeah, she had literally had her 14th birthday, not even a month before this all started.
Regardless, Heather gets a Florida family court case opened. Her daughter's, one of her children, her oldest daughter, is 16 at the time, still a minor, 2 years before she's going to turn 18.
Didn't have a driver's license, might I add.
And then the court system is so slow and
intentionally slow to drain people of their money.
That this case has progressed so long that they have to remove one of the kids from the case because the kid has turned
Aged
18.
out. And Tommy is about to age out.
So we're going to be down to
two minor children.
2 kids that the
and
case is
I'm now going
proceed
to have
on.
2 adult children that have what kind of future? What kind of future are my children going to have?
No.
Tommy, I don't know what we're going to do about getting him in any sort of college. Like, he needs help.
All right.
So, yeah.
So then I want to move on to number 41, because this is something that a lot of people don't understand. I certainly didn't understand. I don't think Heather understood this. I think if Heather knew this was going to be the, part of what she was going to run into here in Florida, maybe there would have something else could have happened in Illinois. But what did I say? 41. This a party petitioning for a change in parental responsibility in Florida has the quote extraordinary burden of providing both a substantial change in circumstances and that failure to change custody would be detrimental to the best interest of the children. Okay. Let's think about this for a second, because there have been so many substantial changes in not only in Heather's life, but the kids' lives.
The children's lives. Yeah,
and
for sure.
Ultimately, what the magistrate gets into,
let's tries
to argue that nothing was substantial enough.
The April 27, 22 Illinois order that should have never happened literally reserved Ariana to both of us. And then Ariana gets dumped down here just over a year after it was written up.
And there was no final determination.
Exactly.
So
that alone was the extraordinary circumstance.
So let's look at some of the other extraordinary circumstances. When the kids moved to Florida, they were actually not just placed with Justin by himself. They were placed with Justin and his parents at his parents' home.
Right.
So Justin didn't even have his own home, and he wasn't on his own, so to speak.
Right.
That's the environment the kids were placed into. And
with
then
3 adults in one house.
Like a year later, he purchased a home in
Daytona.
Not the best area of Daytona. And then the kids moved there. So now the kids are at his home with no other adult supervision, and clearly the Illinois DCF, when they placed the kids down there, part of their decision making had to have included that Justin's parents were there.
Yeah. For
sure. Now, moving on to the best interest of the children, literally what the magistrate is trying to make the argument here is that we recognize that the couple of the kids are failing, have been, absent from school countless number of times. We've seen the TikTok video where he's trying to sell his homemade bong.
That's on the YouTube channel.
It's more than likely one of the kids is holding the camera while videoing it.
Yeah, the cameras are moving, so someone's definitely holding the camera.
So we're gonna ignore all of that and say the kids are better staying there than even giving mom a chance to help the kids. Mom who was hired as a Volusia County public school teacher. Mom who is working on her master's degree with a 3.9, 3.8 GPA. In a house with another person who has a master's degree.
And I just did UCF's virtual fair for PhD in psychology and found out that I would be accepted there.
So, but we're gonna as the court, we're just gonna ignore all of that and say the kids are better off failing in Florida. That's ultimately what he's saying.
Yeah. So I responded. Part of what I responded to is additionally continuing, and this is important from a psychological standpoint. I would love to have any professional PhD in psychology tell me I'm wrong in this. Additionally, continuing to prolong the separation of the parental relationship between mother and children will exacerbate the negative effects on their psychological well-being. Any child psychologist would agree with this statement. This court is failing to protect these children. Yeah. So let's get a psych. In fact, my previous attorney, Rick Brown, actually ordered, it's in my docket from July of last year, he ordered psychological evaluations of all 6 of us Dustin, me, and all 4 kids. And that has sat ignored too.
The court just, they do what they want.
Yeah.
They don't put kids
first.
Doesn't seem like there's any standard procedures. Literally, her attorney files to get psychological evaluations for everybody.
And I was all for it. I'm like, absolutely. We all need to have psych evals.
Hell, even I volunteered to have one myself. Just so nobody could say that there's an issue with me and a reason for the kids not to be.
Because clearly all you have to do is just maliciously say there's mental health issues, and then it follows you in court documents for 5 years straight.
Again, nothing ever happened with it.
No.
The judges never even mentioned it in any of the subsequent hearings.
No. All right. What do we want to touch on next?
Okay. The magistrate says, although it's true that the mother may have subsequently moved to Florida, as stated in her supplemental petition, merely alleges that she relocated within 50 miles of the father and the 3 youngest minor children, failed to allege or show how a modification due to her relocation is in the best interest of the children.
I moved 1,800 miles away from everything I've ever known
but not
to be
only
close
that,
to my children.
Not only that, this is mind-numbing for anybody who's a parent, right? This magistrate is trying to say a parent moving closer so they can be in the lives of their children isn't important.
Mm-hmm.
Moving, and I'm not even just talking about moving closer to be in, within, a short commute. Literally moving across the country to be near the kids. The law in the state of Florida, let's actually back up one step. The actual law in family custody cases in the state of Florida presumes that the best interest of the children is to have both parents in their lives.
Yeah.
That's the baseline of the law.
That's Florida Supreme Court law.
So,
Florida is very much a 50-50 state. Like, it takes a lot for a parent to lose custody in the state of Florida.
So the baseline is the state legislature has said it's in the best interest of the children for both parents to be in the lives of the children. And here you have a magistrate saying, well, she moved closer, but that doesn't mean anything.
Yeah. You
got to be kidding me. It's on its face, it is absurd.
It really
is. Any parent out there would have to understand this, that if you literally just shut your entire life, everything you've known down, pack it up into boxes, pack up your car, drive all the way across the country, because that's what you have to do to be near your children and to try to be part of their lives and to try to help them. That is a substantial change. Now, here's the thing. The law doesn't say there has to be a substantial change in the lives of the children. It just says there has to be substantial change, right? So it could be a change for parent A, it could be a change for parent B, it could be a change for the kids.
Right.
It could be multiple changes. The magistrate's trying to make the argument that a change in Heather's life is not significant. We have to prove that there's been a change in the kids' lives.
Right.
Which is an almost impossible burden given the situation when you have one parent completely blocking all contact from the children to the other parent.
Yeah.
Yeah,
it's just so absurd, and that's why I wanted to wait to explain this until I filed my motion to vacate, because his document was 11 pages. My response was 20 pages with a lot of substantial evidence backing up my responses.
All right. So I want to get into number 48, and I'm just going to go to the end of that paragraph. The magistrate says, even assuming these allegations were found to rise to the level of substantial and material change in circumstances, the mother failed to demonstrate how the father has failed in his parental responsibility related to the educational needs of the minor children. Okay, we literally, when you're trying to,
pages of evidence
when you're showing the court what's happening with the kids' education, what would you show them? You would show them the grades.
The grades, unexcused absences.
Grades and absences
suspensions.
And suspensions.
Suspensions.
Yeah.
Grades,
absences, suspensions, disciplinary record at school when the kids are in the custody of sole custody of one parent, you can take all of that evidence, show it to the court, and you have a magistrate here saying, that's not enough.
Yeah, so
you don't have enough to prove that dad has neglected. Now, I want to remind people, in one of the hearings, Justin told the judge that he didn't have time to go to the high school to talk to the administrators to see what they could do for Tommy.
Yet I was driving 40 minutes away from where we live to Daytona to meet in person with the assistant principal Blum, B-L-U-M, multiple times. I met with her multiple times.
I took time off from my job to go with Heather to each of the 3 schools when she was meeting with the principals and assistant
Mainland,
principals.
Campbell, and Palm Terrace.
Okay.
Both of us went to all 3 multiple times.
And we live 40 minutes away from the closest school. Okay, so now let's think about this. We live 40 minutes away. We made the time to go.
Right.
I took time off work. Heather took time off work. We made the time to go because it's important. How far does Justin live from Mainland High School?
We timed it. It's a 3-minute drive. 5-minute walk, 3-minute drive from his house to Mainland High School.
But he didn't have time to go to the school to try to get help for his son who was failing.
Well, I mean, why would he, Pete? Because when the children were in my care, I was on the PTA at District 114 in Fox Lake, Illinois. So that would have been Lotus Elementary, Stanton Middle School. I was on the PTA for the entirety of my children's education from pre-K at Lotus all the way up to Stanton. Okay. I would literally go in and make presentations to my children's classes as a scientist. Okay. So I always made the time.
I want to stick on the topic of education here because we're going to move on to number 49.
Okay.
So number 49, and I want you to, after I read this, I want you to ask me why this happened.
Okay.
Okay. Because I was in the court when this, when the precipitating incident happened. So I want to explain it. But the magistrate says, in fact, the record reflects that the father did eventually transfer the oldest minor, Tommy, or TS, from Mainland High School to the Richard Milburn Academy in January of 2025 due to his poor grades and unexcused absences.
Yeah, so why did Justin move him from Mainland to Richard Milburn?
What was the date of the hearing in January?
January 8th at 10 a.m.
January 8th, we're in the courthouse.
Or no, it was 9 a.m. 9 to 10:30 a.m.
We're in the courthouse in the hearing with Judge Sandra Upchurch. Mm-hmm. Heather has presented her
85 pages of evidence.
She has presented his grades and attendance. The judge looks at Justin and basically chastises him in open court, saying, she's acknowledging the grades and attendance are a significant issue. At the time, it was not enough evidence to give the custody back to Heather, because
according to Upchurch,
that hearing was actually
it's clearly being paid off.
Heather had filed an emergency motion for custody.
Multiple emergency motions of custody.
But the judge basically said
to get my children some help.
Yeah, and I was personally a witness to this. The judge basically looked at him and said this was going to become an issue ultimately.
And the very next day in Volusia County's parent portal, my portal, Tommy's all of a sudden no longer at Mainland and in Richard Milburn Academy, which is a charter school.
Really what happened, it wasn't that Dad took action.
It was because Judge Upchurch ordered him to take
Heather
action.
has been shining a spotlight on it.
Advocating for my children, even without having any communication with them. So I am still advocating for my children.
Heather's shining a spotlight on the attendance and grades, gets the judge to acknowledge it. That's when Justin actually did something. Because remember, before that, he didn't have time.
Right.
So,
yeah, and when he made that statement, that was in the December 17th, 2024 hearing with then Judge Stasia Warren, who recused herself 3 days after that hearing because I pulled a public records request. That recording of that hearing is also on the YouTube channel under the hearings, where he literally said, I just don't have time.
Right. So line number 53, mother provided documentary evidence that she has obtained a bachelor's degree since moving to Florida, is enrolled and actively participating in an MBA program with a 3.8 GPA, currently that she's capable of properly handling responsibilities and caring, or I got hung up on the words here, and you're in my light.
Sorry.
Enrolled in and actively participating in an MBA program with 3.8 GPA currently, and that she was capable of properly handling the responsibilities of caring for minor children. Okay, the magistrate literally says she's presented evidence to prove she's capable of caring for and properly handling the responsibilities of caring for children.
Academia is my life.
That's in the magistrate's report. But then he says, while it's certainly laudatory, meaning congratulations, none of these circumstances rise to the level of significant or materiality for purposes of modification of a final custody order. Okay, so you have a parent who has taken it upon themselves to better their situation, better their education. That's not enough. It's not significant.
Yeah. So I said contesting General Magistrate Alexander Alvarez's statement as the context of why I submitted my evidence of having a bachelor's degree and working on my MBA with a 3.8 GPA is very relevant, as my children have had a 1.0 GPA in Volusia County schools for 3 years now. Not weeks, not months, years. 3 years. So the entirety of the time they've been down here. Their overall education in Justin Serlick's care is a very serious concern in this case. Furthermore, the April 27, 2022 order was never meant to be a final order, and the word custody is not used once in that 3-page document. Yeah, clearly the general magistrate and Sandra Upchurch and Stasi Warren just want my children to be completely illiterate and have no education whatsoever, so they can amount to anything in life. I would love to know what my children's take on that is. So,
all right. 55 and 56. Now I want to, so if you actually go on and look at the documents, there's a lot of legal case law that the magistrate cites. And while I understand what he's saying is you can't make an argument that one parent's house is better than the others, so that parent should get the kids. We never made that argument. Mm-mm. The evidence that Heather submitted was basically, we submitted evidence, pictures of our house, pictures of the rooms we have ready for the kids, because
they've been ready for 6 months now. So guys, if and when you watch this, Ariana, Tommy, Bianca, Charlie, there have been 2 fully furnished, freshly painted, very nicely decorated rooms ready for you to live and sleep in for 6 months now. Pete and I have put a lot of work into making sure those rooms look beautiful for you guys.
And we actually have a third loft space. So we literally have, separate rooms for everybody.
I mean, those rooms are just sitting empty, not used because of this legal abuse.
But we submitted, Heather submitted, I say we because I'm part of her team here, right? But I'm not a lawyer. I'm not representing her or anything like that.
Right, but the photos were basically to prove that if and when Justin ever tried to say that we were living in squalor or something, it was to prove that we live in a very nicely clean, decorated. Everybody that knows me knows I'm an OCD clean freak. So that was those photos we submitted as evidence was just to keep any of those claims from coming in.
It was to demonstrate also a change in your circumstances,
right? Absolutely.
Because tell the folks what were the circumstances that you were living in when the final family court order in Illinois was signed?
Oh, the April 27, 2022 order. So as I previously mentioned on I think it was Wednesday's video, I was living in my pop-up camper at Endless Summer Camp, or not Endless Summer. I was at Sugar Mill Ruins Campground in New Smyrna Beach. We're talking 120 degree temperatures with the AC running. If I didn't have a lifelong experience as a scout, I wouldn't have been able to make that work for as long as I did. I was homeless, living in a pop-up camper in Florida summer with canvas walls. We're talking canvas, like canvas tenting. That's what pop-ups are. They're canvas with a tin roof. And I was laid off from Garden Health March 25th. So I was homeless in an RV, not a lavish RV by any means, and jobless. Yeah, so I went from that to living in Pete's childhood home. He's been here for over 30 years, and we are here together by ourselves. It's not like we have roommates or family living with us. It's just us two. 4-bedroom, 2-bath house with a loft, a furnished loft, and a massive in-ground pool.
And we're a team. We
Right.
help each other out. We take care of each other. We take care of our house. We take together. We take care of the cats.
Like real couples should.
2 cats and a dog.
Yeah.
And I mean, again, the law states a significant change in circumstance, and it doesn't say it has to be for the children or the custodial parent. It says just a change in circumstance.
What is extraordinary burden of change in circumstance? Is it death?
I mean, we're talking about
what is the other option? Death? Someone dies in the family?
Going from homeless and unemployed to sharing a home and running your own company.
Well, not only that, let's think of this. So April 27th, 2022, I didn't even have my bachelor's degree yet.
No.
I earned my bachelor's degree May 13th of 2022. So I went from homeless, jobless, and degreeless. I didn't even have a degree yet. To now I have a bachelor's in science since May of 22. Now I'm almost 2.5 years into my MBA in marketing, and I own my own LLC marketing company and 2 nonprofits, one of which is dedicated to my 4 children, Justice for the Serlick children. So yeah, I think I've come a very long way since April 27, 2022, for an order that was written up behind my back with no legal representation in a state that should have never written it.
Okay. So next, I want to, and this may get hard because these are some hard points to look at. Actually, I want to go to 61 or 62 first. Okay. Well, really, we're going to go back onto the education, headline here. So 61, the children's school and attendance seems to have stabilized with the father, and the father did take recent steps to transfer the school of the oldest child. No evidence was presented at all. Remember, Justin presented no evidence.
It's actually in the progress docket hearing notes.
The
Alvarez
magistrate,
wrote 0 evidence, 0 witnesses.
We don't know what he looked at to say the attendance has stabilized.
Because I lost access.
We don't know what's happening with the attendance. We know what happened with the attendance up until Heather lost access to the parent portal for Tommy.
Which was about 2 weeks after he was moved to Richard Milbourne, January 9th.
So we know
right around my birthday, I lost access.
We know when he first started going to Richard Milbourne.
Unexcused.
He was still unexcused.
Day after day.
So there was no proof presented that attendance has stabilized or grades have stabilized.
Right. And Justin submitted no evidence of such to Alvarez. So where is that coming from?
Then,
Mary and Ira, where is that coming from?
62. The children's reasonable preference was not lawfully presented in the hearing. The mother often tried to testify to inadmissible child hearsay. So let me mention a couple things here. And the reason I understand I'm talking a lot in this video, Heather's made several videos, and I want the people that watch the videos to understand that, sometimes Heather might come across, and anybody that makes videos like Heather does, who's been a mother in a situation like this, sometimes you're watching the video and you start to question, like, did everything really happen that way? Is that really going on? So I wanted to be on here. I want to give you guys,
but I bring receipts.
I want to give you another voice and some context here. So when you're talking about the child's reasonable preference, okay, how the children are not allowed to testify,
right?
In
and that's Florida law.
So how do you get evidence of what the children want?
A guardian ad litem.
When you have no, essentially all your contact with the kids has been cut off.
Therapists, guardian ad litems. That's how you get them involved.
Guardian ad litem.
Yeah.
Heather's second attorney, Rick Brown, did file a motion to appoint, they call it an attorney ad litem. Basically, it's a guardian ad litem, but it's somebody who's also an attorney, friend of your attorney, who knows,
Yeah.
right? But it never went anywhere.
We already know guardian ad litem Kathleen McGee was bought off by the Serlicks, and that's how the kids ended up down here. So it can go either way, but they do exist.
The reason, for those thoughts is, a guardian ad litem is supposed to represent the best interests of the children. To determine the best interest of the children, you sort of have to you have to understand both parents, right? So
absolutely.
At least have a conversation on the phone. Heather, did you ever talk to the guardian ad litem in Illinois?
I don't even know what she looks like or sounds like.
Okay.
So no.
So, now
all I know is she resigned.
Okay. Now, your attorney had filed to get an attorney ad litem appointed in your case.
July 24.
Your attorney told you it was going to cost each you and Justin, I think it was $1,200 a piece.
Yep, and we agreed to it.
And we were ready to pay, right? And Heather's attorney told us that Justin and his attorney said they didn't have any money. So it didn't go anywhere.
Right.
Now,
it just sat. It's still sitting.
Heather, in the state of Florida, there's a guardian ad litem program.
There is.
How do those guardian ad litems get pulled onto cases?
The judge appoints one.
How much does that cost the parents?
Absolutely nothing. It's volunteer. Volunteer guardian ad litems, Florida guardian ad litems, are volunteer based, and all you need to get one appointed to your case is the judge has to make it so.
So we're going to finish on, because that's literally the last point of the order, so we're going to circle back to the issue of guardian ad litem. But without having the guardian ad litem, without having the children's ability to testify themselves, what can you do, right? Well, when I went with Heather to Palm Terrace Elementary School, after meeting with the principal and the guidance counselor for over an hour, we both met with them, we were in their office, they said, hey, do you want us to go get Charlie and bring him down? We did not know if they would do that when we went there. I mean, it was a meeting to speak to the principal and
right. I wanted Principal Troutman and Counselor Emily Sweet to understand what Charlie has been through, so they can better support him.
They bring Charlie in, and we ended up spending probably close to another hour with Charlie. If you can imagine, Charlie hadn't seen his mom in person in a few years. So it was a little awkward at first, but he opened up pretty quickly. So I met him. I talked to him a little bit. They talked about what he had been up to, what his favorite things to do are. Just the very basic stuff that you would normally ask, your kids every day when they come home from school. Hey, what did you do? But they hadn't seen each other in years, so everything was new information. Now, I was there as a witness to all of this. Heather had called me in the magistrate's hearing. Heather had called me to testify. Now, I understand the law, and this is just standard court law, so this is applicable everywhere in the country. Hearsay is when one person tries to testify what someone else said. So even though I heard it with my own ears, and I witnessed the conversation, and I saw, Charlie moving his lips to have the words come out.
You couldn't say on the record what he was actually saying.
The court can't understand, the court can't consider the words. Now, in the testimony, I said what the words were. What Charlie told us was that, and this is not an exact quote, but it is very close. I already have a suitcase, so I can come visit. So he very clearly, very much wanted to come. He also
it was not
he also
not
said,
a lead on. He said it on his own.
He also said he wants to tell the judge what he wants.
And during our lunch, so after that initial hearing or that initial meeting with the Emily Sweet, the counselor, and everything, I then started having to go have lunch dates with him at Palm Terrace. So I would actually drive from Edgewater to Daytona at 11:30 a.m. and we would sit for lunch together. And Charlie multiple times, Mom, when am I going to get to tell the judge what I want?
In
Florida, you're not allowed to.
So they can't. The judge and the magistrate can't take what we say. What they can't consider what the child told us.
Right.
In that.
But that's
I
where
testified,
therapists and guardian ad litems come in.
But I did testify that in general, it was very apparent by physical manifestation, Charlie wanted his mom in his life.
Yep.
Now, it's, how else are you able to prove it? Well, what did we have available to us? Heather said she was going and having lunch dates with Charlie. Mm-hmm. She took pictures.
Photos.
And photos. You took some videos, didn't you? I don't know. Maybe it was just photos.
It was just photos, but on the last day of school last year, I actually brought my children's cat Willow that they had since October of 2019.
So
I have photos of him holding Willow.
You can see he was happy to be having lunch with his mom.
And then let's fast forward to February of this year. You can look at the picture.
Heather's she'll post one or two of the pictures probably.
Yeah, but let's just fast forward to February of this year. The 3 voicemails my children left me. Those voicemails, all 3 of them, are on my YouTube channel under playlist voicemails. You hear Charlie say, "Let's just go see her."
Yeah. So.
It's just mind-boggling.
Yeah. So we submitted that, but the court's trying to say, no
it's
evidence.
Insubmissible.
We nothing was significant enough for us to determine what the kids want.
Yeah.
Okay? Well, I can tell you as somebody who was, from a family where parents got divorced, the kids want both parents in their lives in most cases.
And you even can say even more personally that both parents should be part of your lives because you did lose your father at a young age.
Yeah.
So you can absolutely say that.
I can tell you, not having a parent in your life as a child has a significant impact on you throughout the rest of your life.
Absolutely.
Now, in my case, right after my parents were divorced, my dad was killed in a car accident. Yeah. And I was in the accident with him. So
So
you can
he
imagine,
definitely can
worst
speak
that life can present to somebody.
In regards to one parent not being there, they just in an instant is gone.
I don't even have the option of my dad being in my life because he died when I was 12. Heather's kids, they have an option for Heather to be in their lives. And the system is stealing that option from them.
Yeah. They are absolutely victims of this horrible system.
This next one, okay, so 63 and 64, these are the hard points. Mother did accuse the father of raping her in the past, but father denied these allegations, and no other substantial, competent evidence to support mother's allegations was presented.
Okay. Read the police report. My children actually say they witnessed it.
Unless you have video of it happening, right? What kind of evidence can you present?
Children literally telling investigators that they heard mom say dad to get off of her in the RV.
There was police reports, multiple police reports filed prior to the initiation of any case in Illinois.
Yep.
Okay. And we submitted those police reports.
Yep.
Okay. Now,
multiple times. It's in my docket
to the allegation that Justin denied it. If you actually go back and watch the hearings, watch closely when he's being accused of that, and listen closely to what his response is. Most of the time, he stays silent.
Doesn't say, I never did that.
The only denial I heard in the recent hearing, Heather questioned him, how many other women have you raped? And his response was, I haven't raped anyone.
And then my immediate response is, well, you did rape me. Okay. And then he went silent after that. So multiple times in multiple hearings going all the way back to November of last year with his attorney, Serena Baldacchino, present, I looked him straight in the eyes and I said, you were raping me for years. You know what you were doing. He would just sit silent. Now, Pete, if I'm looking at you and in front of a judge, and I say, you were raping me for years, and you know for a fact that's not true, what would you have said in return?
I will raise holy hell denying that allegation.
Right. That would be human nature. If you're accused of something,
be the normal response.
If you are accused of something that both of us know that didn't happen, your absolute human response is going to be to defend yourself, not sit silent.
So, then 64 is the mother repeatedly accused the father of neglecting and abusing minor children while in his care. She failed to support this allegation with any confirmed DCF reports or other substantial competent evidence. To the contrary, Illinois Dependency Court, blah, 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 blah. Okay, again.
After the hearing.
Again, let's break this down a little bit. You don't have direct contact with the kids.
Right.
So you can't get any current present information from the kids as far as what's going on. But,
just their grades and their attendance.
Grades and attendance alone should. I mean, it tells a story, and anybody that has kids that have if you have kids or know of kids that have grades and attendance that match what Heather's son has in school, you know those kids are having problems.
So let's put a pause on that. So for me, I have always been an exceptional student, kindergarten all the way up to current, 3.8 GPA in my master's program. So I always had straight A's, honor roll, AP classes. When I started to have my own family life issues around 12 years old that involved my mother and my stepfather, and then at 15 with my grandmother and my grandfather, the one thing that my teachers and my counselors at school in Round Lake Middle School and RLHS, Round Lake High School, would always say to me is, Heather, what's going on? You've always been a straight A student. You're skipping class. Your grades are falling. You're not doing your homework. What's going on? How a kid does in school is a direct reflection of their home life. So I was taught this at like 12 years old. How a child does in school is a direct reflection of their home life. So let's just take a look at my children's straight A's, National Junior Honor Society, perfect attendance certificates in my care, to extreme unexcused absences, 1.0 GPA for 3 years, suspensions, school suspensions. Tommy and Bianca both have school suspensions on their records in Daytona schools. Let's just compare those two scenarios to before and after and apply how a child does in school is a direct reflection of their home life.
I mean, it tells a story.
It does, absolutely.
Now, that being said, you can't make this up, but literally, as soon as this magistrate's hearing ended, this hearing was conducted by Zoom.
The timing.
As soon as this hearing ends, Heather gets a text message from a Florida DCF investigator because a case has been opened against Justin. Yep. Now, we ended up, after talking with him briefly on the phone, we went up to his office to talk to him. It's very interesting because he did inform us that he had gone out and spoken to Justin and the kids. But
got a completely different story.
He told us that he got a completely different story from them.
Of course, because parental alienation.
Now, here's the thing. We didn't just go up and tell him our side of the story.
We gave him a stack of evidence.
Basically,
in a big rubber band folder, one of those file folders that attorneys carry around.
Here's the thing. There were things we told him that he was unaware of because things that should have been reported to his agency were not.
Like Tommy's suicide in Justin's care that was kept a secret all these years.
According to the DCF investigator, more than likely, the Daytona Beach Police and or the hospital should have reported that to DCF.
But the bigger problem is no one in this area seems to actually do the job they're paid to do. They're a title and a paycheck, so that requires an extra step.
The other thing,
so why would they
the other information we found out was that his investigation did not stem completely from any report that Heather or I or anyone we know made. There was other reports being sent to him.
Yeah.
So we've filed for a public information request to try to get some details.
Freedom of Information Act, guys.
We know, unfortunately,
it's all right.
just based on timing from some other requests that we filed, we know it's going to be another month and a half probably before we get the reports. But we'll certainly share those when we get them.
Yep.
To
so we'll eventually find out what that other report was, because he
at some point the reality is at some point they can't keep hiding what's really happening.
Right.
You know, the truth is slowly starting to come out. Their glass house is starting to crack.
And that's what my nonprofit is all about, is shedding light on,
now, 65,
on all of this.
So I want to move on because I don't want to again be bogged down.
Okay.
Right? 65. Now this is just like this speaks volumes of how little the magistrate paid attention to any of the documentation.
Right.
65 states the mother failed to present an updated family financial affidavit or any other financial documentation, including mandatory child support guidelines worksheet, to support her petition for modification of a previous child support order.
Hang on, let me just read my response to this, because when I read this, I was like,
"You got to be kidding me!"
God,
is the response on
this guy doesn't read. Does he know how to read at all? Because it's very clear he doesn't know how to work a Zoom conference. So my response to that is contesting General Magistrates Alexander Alvarez's statement as mother filed her updated financial affidavit when she was ordered to by Judge Stasia Warren at the in-person hearing November 5th, 2024, which was filed November 15th, 2024, and is DIN number 49. Then Heather Bendl filed a child support modification, which includes another financial affidavit, November 21st, 2024, and is DIN 62, which triggered a summons of Justin Serlick. Justin Serlick has still, as of April 2025, refused to comply with the summons to produce his financial affidavit, which is needed by Florida law by both parties in order to do the child support worksheet. This is further evidence of legal/judicial abuse and manipulation of our court system.
Now,
he should be held in contempt for that, because he was literally summoned and ordered by Circuit 7 to produce his financial affidavit back in November, and he still has yet to do that.
He was actually, as part of one of the early on proceedings that Heather's attorney Rick Brown filed, they call them interrogatories, but basically it's the two attorneys get together and they say, we need you to give us this information, you need to give us this information.
Right.
And so that was all supposed to happen. The attorneys knew what was supposed to be provided, but
the illegal contempt hearing happened.
Justin's attorney never provided the documents. So then Heather, when she was representing herself, figured out what to do, filed the modification order, which triggers a summons that was served by the sheriff's department, and we got return service on it. So we
know he was served. He has yet to produce that. Got to cough it up eventually, Justin.
All right.
One way or another, you got to cough it up.
68. Any mother who has been in any situation even half as complicated as you is this is gonna hit home for them. Okay. Finally, the undersigned, meaning the magistrate, would be remiss if he did not specifically address the openly hostile and aggressive behavior and conduct of the mother throughout the proceedings, and specifically at these hearings before the undersigned. Okay. Two points I want to make. As a parent, imagine for a minute your children have been ripped out of your arms. And when I say ripped out of your arms, I literally mean the investigator pulled Bianca out of Heather's arms.
Yeah.
You don't have any meaningful contact
Bianca
with your
and
kids
Charlie
for 5 years because your ex-husband lied to investigators.
Mm-hmm. Which is happening across this nation.
Would you
this is
would you be able to keep 100% composure when you have to look at the person who's triggered all of this by his lies?
The person
who would be a little irritated. Okay, now
the person that kicked my son in the ribs 3 times and then physically picked him up and threw him through the wall and then turned and looked at me and told me not to let him do that again, as if I'm able to control his anger and emotions. The person that would yank my daughter Bianca out of out of her bed every morning and scream at her to clean the pee off of herself because she has epilepsy while he went back to bed. That's how our whole household woke up. The person that took advantage of me for years after I took my Xanax and Ambien, even though we were in separate bedrooms on different floors of the house.
So, you know,
I don't know how I've managed to compose myself as long as I have. I think I'd give myself a few kudos there.
I've told Heather what my general thoughts on it are, but I can't say that on camera because it would be misinterpreted. But yeah, you can imagine there's reason to be hostile. Now, there's an additional factor to also consider here. And we didn't address it at the very beginning because it's actually mentioned in the first paragraph. Heather has a hearing disability. Okay, she's completely deaf in her right ear.
Born deaf in my right ear.
That's why I'm sitting on her left side so she can hear what I'm saying.
Mm-hmm.
So when you're in person, and even, you know, especially when you have a Zoom hearing, okay, there's a few things that happen, and this is physical. You know how it happens with her. One, because of her hearing disability, she does not always understand what her actual voice volume is.
Oh, I'm very loud.
And
I've always been
and
loud.
Most hearing impaired people in their normal conversation speak at a higher volume. So
I was also raised by my grandfather, who was practically fully deaf. So I always had to basically scream.
That's you know, a factor. Now,
I'm also tone deaf. So sometimes I come across, and I know this about myself, and a lot of my friends that have known me most of my life just understand this about me because they grew up with me. So I sometimes sound rude or hostile when I'm not.
And then
then add the fact that I have RBF, and then I just look pissed off all the time, and I'm not.
The other thing that happens, and this is something, you know, I've been together with Heather for 2 full years now, and it's taken a little bit to learn to understand what's going on. But because of her disability, hearing disability, while she's talking, she actually can't hear other people talking. So when she's on a Zoom and she's talking,
I can't hear anything
she actually
else.
can't hear that anybody else is talking on the Zoom. So it comes across that she's intentionally trying to talk over people.
I don't have surround sound.
But you know, if she's talking and pauses for half a second and somebody else starts, you know, in her mind she wasn't done with her thoughts, so she continues talking. It comes across as if she's trying to intentionally talk over, and most of the time that's not the actual intention. She just doesn't hear.
Which is why I have my CART services so it's a transcript. Again, anyone who's known me most of my life knows that I watch movies and TV with closed caption on, because I oftentimes, especially when I'm in a loud setting where I might be conversing with people while I'm watching TV, I can't hear everything. Yeah. So I intentionally read. Yeah. So my CART services in court is transcribing what people are saying to me so I can read it.
So I want to, you mentioned the CART services, so I want to make sure we nail down this point too.
Yeah,
right?
This is a federal violation.
Well, not even that, but the magistrate, you know, says that, you know, your behavior and conduct throughout the proceedings that he personally saw. So there was 2 hearings that the magistrate had with Heather. Well, technically there was 3, because there was a hearing with Heather's first attorney, but we were just observing that one. Heather wasn't actually part of that hearing.
Yeah, he didn't see me on camera at all. I was not on camera.
The 2 hearings
probably didn't even know I was there.
The 2 hearings where the magistrate saw and interacted with Heather. What happened in the very first hearing that raised your level of irritation?
Violating my rights. First of all, my federal rights for the CART services. So that's federal ADA rights. That's federal violations right there. And then second of all, Florida is a very open court system unless it is officially a closed case where only certain parties can be involved in the case, which mine is not. Mine has never been designated a closed case. Florida Supreme Court law is very, very clear that anyone can court watch. I had, and it was documented, I had 15 court watchers trying to get into that hearing February 25th, and he refused the 15 court watchers, or maybe it was 14. He wrote it down. It was either 14 or 15 court watchers. He refused them, which is a violation of Florida Supreme Court law. So he violated Florida Supreme Court law and my ability to have witnesses to what was happening. And then he violated my federal rights for those cart services that weren't working. And I was very clear, the recording is on the YouTube channel as well. I was very clear, we are not moving forward until my cart services are working. This is my ADA. I have a right to it. And you can hear him just keep pushing and trying to continue without the cart services. And yeah, I was getting upset because he was violating federal and state laws.
He's basically trying to put the blame on Heather for his own failures.
Yep. Because, why would anybody take accountability for anything? It's just apparently all of this is my fault. So I want to actually read the response to that one because I want everyone, including my children that are going to eventually watch this someday, to hear my response to that, because there's always two sides to a story, right? There's always two sides to a story. And then somewhere in the middle is the truth. That's what I've always been taught by my grandpa my whole life. Two sides to a story, somewhere in the middle is the truth. All right, so contesting General Magistrate Alexander Alvarez's statement. While I acknowledge that my behavior may not conform to societal norms and court decorum, which Justin Serlick kept trying to use that, try to pretend like he has a JD and he knows court word verbiage, court decorum procedures. However, I am a mother who has lost any and all contact with her 4 biological children for 5 years now, who has been forced into ongoing and prolonged litigation with my rapist and abuser, Justin Serlick, with no reasonable support, including domestic violence advocates by my side. It is also important to note that Heather Bendl has physical evidence as of January 7, 2025, that there is illegal corruption involved in her case against Justin Serlick by Illinois Circuit 19 Michael G. Nurheim, who was the state attorney that failed to protect Heather and her minor children from their abuser, Justin Serlick, in September 2020, when Heather and her children came forward to the investigators with the abuse over the years. Additionally, Heather Bendl is legally deaf in her right ear and is tone deaf, which can be portrayed as talking loudly or aggressively. It is also important to know that in the past 5 years, there has been no formal professional psychological evaluation entered into evidence proving that mother has any psychological or mental health concerns, and Heather Bendl respectfully requests that unless there is a professional document stating as such, this court refrain from accusing Heather Bendl of having any mental health issues, as only a mental health professional can state such accusations. Mother has completed all stated services required by the state of Illinois, which was 5 years ago. Anything prior to the April 27, 2022 order really should not be of any relevance to this Florida Circuit 7 at this time. All right.
So, and we've been on, I think we're well over an hour now. So,
I knew this was going to take a while to go.
The last point I want to hit, because we're circling back. I said we were going to circle back to the guardian ad litem issue. So, the last point that the general magistrate makes in his findings of fact says, regrettably, although the mother had previously filed pleadings in July 2024. Okay, so Heather's attorney, through her attorney, back in July of 2024, almost a full year ago from today, filed a motion to request the court to appoint a guardian ad litem. Almost a year ago.
Yep.
And the judge didn't do anything with it.
And we now know that all it takes is a judge to appoint a Florida guardian ad litem, and one is assigned free of charge. Free of charge.
So the magistrate says, so the mother previously filed pleadings in July 2024 seeking appointment of a guardian attorney or guardian ad litem. For this case, both parties stated they each lack funds to pay for the appointment.
Well, they're free.
I want to make, wait. The actual, the volunteer guardian ad litems don't cost the parties anything.
Nope. Just has to be court appointed by a judge.
The cost was coming from, originally Heather's attorney wanted to use an attorney
ad litem.
And so there was going to be a cost. Now, here's the thing. We never said we couldn't pay. We've never testified we couldn't pay. We were ready. We had cash ready to go. We wanted to pay.
Absolutely.
We were waiting for Heather's attorney to tell us who we needed to pay.
I want eyes on my children. My children need help. I want therapists in their lives. I want guardian ad litems in their lives. I want people to actually hear what they have been told and what they are going through. And that is why the Serlick family is trying so hard to keep anybody from being involved with my kids, because then people are going to start learning the truth.
So that pretty much, now there was more to the magistrate's order, so feel free once Heather posts it to
all of it's going to be on there.
Look at everything. We just, for a matter of time, we can't hit every point,
right,
but we hit significant ones here. Since this magistrate's order was signed,
I've been a busy bee.
Few things have happened. Heather has officially filed a motion to vacate. So
which was that?
That's sort of a step you have to take. If you ever want to appeal anything, the lower court, which is the Circuit 7 court, you have to afford them every opportunity for them to correct their issue.
Right.
So the last, sort of stage is...
So this is my motion to vacate with a ton of evidence proving my side of the story.
So Heather filed the motion to vacate with the court, but... to get things rolling, because honestly, we were fully expecting within an hour or two of that getting filed, it would get signed by the judge with a denial.
Like everything else she's been filing.
Heather has also filed a notice to appeal.
To appellate court.
This forces Circuit 7 to transfer or to initiate the appeal procedures with the 5th Circuit, 5th District Court of Appeals. Which happens to be across the street from the...
They all play golf together. They all go to lunch together.
But the thing about the appellate court is they look at the documents and the paper, and you file written pleading or a written brief with them. So there's not going to be, more than likely, there won't be an in-person hearing with one side trying to talk about the other side. Now, the appellate procedures we've been learning is a fairly complex process. There's specific timelines. You have to file certain things. There's some stuff has to be filed within 30 days, within 10 days. 50 days from the last time you did this, something else has to happen. So we've got the handbook. We're working through it to make sure we try to hit all of the points.
So the notice of appeal and the motion to vacate were both filed yesterday, April 10th. One was in the morning, one was at night, because I'm also busy getting my nonprofits off the ground. So I'm doing all of this in between other things. Right. So we are now on DIN 156, guys. Docket identification number 156.
So in the meantime, while getting those filed, one other sort of just little interesting fact to note, Heather got in touch with another mother who has been dealing with a family law case. Now, this other mother happens to have attended some law school herself. She is apparently very knowledgeable on one aspect of custody law.
Thank you for your help.
So Beth, we actually really value the Zoom meetings we've had with you, if you see this. But there's one aspect of child custody law that she brought up to us, and we started sort of digging into that. And
it's going to be fun.
we can't talk about the details.
We're not going to give out our smoking gun, but it's going to be fun.
At some point, I think the world might be absolutely upended and shocked at what potentially can happen here if the appellate court
does what they're actually supposed to do.
They should do, and I'm not talking about Heather's pleading for the benefit of her kids or anything like that. This is a strict paperwork issue that can upend everything. and we've got, you know, when we started digging into this, honestly, we were both kind of shocked and dumbfounded some of the stuff we came across in Heather's case, and what was done when, and who did what when.
Oh, I'm thoroughly convinced they knew exactly what they were doing wrong.
There's
and
there's
they
some
did it anyway.
There's some,
and it's going to land
points,
people in lawsuits where I'm going to be suing all of you.
At some point, we're going to be able to sort of share all the details with people, and you can draw your own conclusions. But it certainly seems like they were fully aware of the provisions of this one particular law, and they
did
were
it anyways.
trying to sneak in under the radar. But they apparently forgot to do a couple things that are very important with legal procedures, and we're gonna call them out on it.
Yeah. So today, both of those were filed yesterday, April 10th. So the motion to vacate the general magistrate's recommendations, and then the notice of appeal on Sandra Upchurch signing those recommendations. Because those both have their own separate things that I want to happen. So today, what has happened is Upchurch assigned a notice of hearing. Okay, so now we're on DIN 160. A few of the DINs in between my notice of appeal and this was just my indigent status, waiving all the fees for the notice of appeal, $100 appeal, etc. Because, you know, all these attorneys have drained me of my entire funds, so I am flat broke. So I don't know where, you know, they expect me to pay this $1,785 a month and this corrupt contempt hearing that happened back in November behind my back. But I'm broke, and I keep filing and proving as such in my docket, just so it's everywhere in my docket. So when fresh eyes get on this, they're like, wait, you're ordering mom to pay $1,785 to dad. She has no contact with her children whatsoever, but she's so broke that she's getting the fees waived, and she's on Medicaid for insurance in the state of Florida. What? Anyways, so DIN 160 is Judge Sandra Upchurch assigning May 2nd, 2025 at 9 a.m. in person for Petitioner, my motion to vacate recommended order of the general magistrate and order adopting recommendations, DIN 155. The hearing will be held at the Stephen C. Henderson Judicial Center, 125 East Orange Avenue, courtroom number 9, Daytona, Florida, 32114. All parties must appear in person, 30 minutes reserved. So guys, I absolutely want court watchers in person for this. Remember, this is a soap opera playing out right in front of you guys, so grab your popcorn and come watch the shit show.
30 minutes is not a lot of time to do anything meaningful. So, you know, what's going to happen? Are we going to walk in and she's going to just say, yeah, we're dismissing everything? Or is she going to say, okay, I guess we'll schedule a trial, right?
Who knows?
We don't know.
Who knows? So, they're playing by their own rules here. This is all illegal activity from the very beginning of it. So they're playing by their own rules. Anyways, so DIN 161. Hey, Willow. Say hello to everybody. Little Willow. DIN 161 is the appellate court. Notice of appeal in the above referenced case was received for filing on 4/10/2025 in an effort to assist you and expedite the preparation of the record on appeal. Please review the information provided below. And it's 1 through 8. And then appeals court. So literally in less than 24 hours, I e-filed this at 10:30 last night. And this has a timestamp of 10:53 a.m. I've got literally instructions and telling me what to do. That's more than Circuit 7 has been doing for me in 2.5 years now, pretty much. So in less than 24 hours, I've got a laid out instructions of exactly what they want and when, preparation of the index, appellant procedures, all pleadings must be submitted on 8.5 by 11. So look at that, guys. All of a sudden, things are being done with proper procedures, and I'm being told what my actual rights are. And then 162 is just acknowledgement of a new case in appellate court. So 5th District Court of Appeal has received a notice of appeal reflecting a filing date of April 10th, 2025. And this is the same timestamp, 1053, just different DIN numbers. The county of origin is Volusia County. The lower tribunal case number is provided 2023-03128. 031-828-FMCI. The filing fee of $300 is waived. Case type NOA final, Circuit Family Other final. And then filing fees may be paid, and then it gives instructions on how to pay it, but it also says right above the $300 filing fee is waived because of the indigency form. The 5th District Court of Appeals case number must be utilized in all pleadings and correspondence filed in this case. Moreover, all pleadings signed by an attorney must include the attorney Florida Bar's number. And then pursuant, and then it's giving rules for a said attorney, and then I'm pro se, of course. Any party who may properly proceed in this court pro se, i.e. unrepresented, may find useful the pro se self-represented appellant handbook. Well, we've already got it. It's already printed. It's already bound, and Pete and I have already been reading through most of it. So yeah, and then so this was copied to me, the Volusia clerk for Circuit 7, I would assume, and then Justin Derek Serlick. So that's where we are now. So I've got this 30-minute hearing in person at the Daytona Courthouse with Sandra C. Upchurch, May 2nd at 9 a.m., where she is ordering me to provide a transcription of the general magistrate hearing from March 25th, which is literally for the whole world to see.
So this is
on my YouTube channel.
Here's we'll end the video on this, but something for people to understand the way, and we've run into this. You don't expect this, but the Florida Circuit 7 Family Court does not provide court reporters for family law cases. So
you have to pay all of it on your own. That's like $1,000.
So let's. I want you to understand this. For Heather to get an official court reporter transcript, she has to pay for the CD recording of her hearing. Then she has to hire a third-party court reporting company to listen to the CD and write up an official transcript, stamp it, and file it with the court. Okay, and you have to pay that third-party company. Which is, from what I've been hearing from other Circuit 7 victims, because we're all victims of this insanity and illegal activity, it's going for about $1,000. So it is a racketeering circle of everyone screwing over people that aren't wealthy. At any rate, we're gonna look into what actually has to occur, whether
I'll be making some phone calls Monday.
If it's possible if there's a fee Heather has to pay to the court to have one of the actual county court reporters do this, or if we truly do have to have a third party company do this for us, we're going to find out. We'll share it with everybody. But okay, listen to this, because you can't make this shit. I'm trying not to curse. The judge is requiring Heather to have a transcript prepared for this hearing. The only way to get a transcript is that the original hearing has to be recorded.
Oh, and she even says in here, if I don't provide it, she will cancel the hearing on May 2nd.
So Heather has to pay to have a recording of the original hearing transcribed and then filed with the court. But Heather, what did she say was going to happen? Or not happen at the hearing on May 2nd?
May 2nd?
Or, yes, was it May 2nd?
Oh, yeah, May 2nd.
Yeah. What she said is not going to be happening.
Are you talking about this line right here?
Where she says the hearing will not be recorded.
Oh, yeah. Okay. I should just read this whole paragraph.
So they're going to hold a hearing with no court reporter. They're not going to record it. So Heather will have no way of actually producing transcripts that could be used
of the May 2nd hearing
in a future appeal.
But I have to pay for the CD of the general magistrate, which is I already paid $20 to get the 2 videos from the public records, and it's on my YouTube. So the whole world can watch what happened on March 25th. And she's now ordering me to order a CD of the proceedings, before the general magistrate, call the Office of Digital Court Reporter in Daytona. Moving party must have his or her arrangements for the production of an accurate transcript, which must be prepared and certified by an impartial court reporter. Said transcript must comply with the requirements set forth of judicial administration. Transcript costs will be borne by the requesting party. And then in all capital letters right underneath, if the transcript is not delivered to the judge and provided to all other parties not less than 48 hours before the scheduled hearing, the hearing will be canceled. So this is all a racketeering money scheme. This is a money scheme.
Yeah, but I mean, just let's look at the logic.
Everybody makes money off of it,
the family
while
court,
we as victims of this court system get screwed.
Every other level of court and type of case, there's a court reporter. But family law cases, no court reporter unless the parties pay for a private court reporter service.
Because why would they want to provide evidence that they're actually doing illegal activity and felonies and constitutional right violations, civil rights, due process?
All of the courtrooms have a built-in digital recording system so that they can record hearings. But her judge has said, we're not going to record the hearing. If you're going to want a transcript, you have to pay for a court reporter to come to the in-person hearing. Third party
for $1,000. So Circuit 7 moms out there, you know exactly what I'm talking about. We talk about it in our group. So, you know what I'm talking about. This is just all a money scheme.
It really seems like this judge is doing this intentionally and vindictively because Heather filed a notice to appeal. The judge is basically stepping in and saying, oh, you think you're going to appeal? Well, we're going to have another hearing, and you're not going to be able to have a transcript because the judge knows Heather doesn't have the money because Heather's filed 2 financial affidavits and filed an indigency form.
Multiple indigency forms because Rick Brown and Mary Jane Nettles drained me of every penny I've had after Thomas Hunter in Illinois drained me of $43,000. So we've
said a lot, and we're.
But this is fun. This was fun. This was a great week. This was great.
It has been a learning experience for sure.
I need to go to law school so I can help other victims of this crap.
It is late on a Friday night. So we appreciate everybody that's watched, everybody that has commented on the video here. We greatly appreciate you. Heather greatly appreciates everybody that is supporting her in her corner. I greatly appreciate everybody that's supporting Heather in her corner. I wanted to be on this video tonight because I want the world to know that Heather's not in it alone, that there are some people supporting her, but obviously more support the better. And that's where things are at right now. So case
have a great Friday, everyone.
No means done, but we want you guys to have a great weekend. We've got a few fun things planned for this weekend. So we're going to leave it at that. Heather will see you all again probably next Friday.
Well, I'll probably do an update maybe next Wednesday.
I was going to say, you have choir on next Friday.
I do.
Good Friday.
I do. Easter Friday, Good Friday, and then Easter Sunday. So I got a total of 4 performances next Easter weekend.
George here wanted to be on camera too. So say goodbye, Georgie.
Anyways, so I'll probably go live again next Wednesday or maybe Tuesday just to give you guys an update on what I found out when I make phone calls to the digital court reporter to find out about this transcription Upchurch is ordering, and then as well as I'm going to be calling the appellant court on Monday and verifying this list that they told me what my next steps are, because I'm going to have fun with this appeal. So stay tuned. Watch this saga unfold. Grab your popcorn, grab a glass of wine, and enjoy. Have a great weekend, everyone, and thank you for watching this, and I appreciate you. Peace.